Good afternoon, ladies and gentlemen. Many thanks to EU-China Joint Innovation Center who invited me to this webinar and to share with you some information about the pharmaceutical patent linkage system in China. To introduce myself, I am JingZhao, a Chinese patent attorney working in a French IP firm. Our firm, IRR, was founded in Paris in 2000 and opened our Beijing office in 2008. So it's been over 12 years that we accompany our French and European clients to develop in China and to obtain and make use of their IP rights in China. Now let's come to our subject of today. For those who do not work in pharmaceutical field, we are going to quickly go through the reasons for establishing a patent linkage system and what is understood by this notion. Afterwards, I will briefly introduce the actual practice in China with this regard. And finally, we will focus on the new system that is being prepared in China. As introduced by Mr. Zubimandi in the first presentation, the pharmaceutical industry is very dependent on patents to ensure the market exclusivity in order to recoup its substantial R&D cost in proving the safety and efficiency of a drug. Without exclusivity, most products will be immediately copied because the technical barriers to entry could be easily overcome nowadays. On the other hand, once the patent expires and the competitors are authorized to enter the market, the price of the drugs will be largely reduced due to the market competition. So the generic drugs help to improve the availability of the drugs, which is also very important for medical system in any country. Thus, there is a fundamental conflict between innovative drugs and generic drugs, and a system is needed to reconcile them so as to balance the interests of different parties. In addition, before the drug enters the market, it has to go through drug registration to get the regulatory approval. Especially for innovative drugs, this registration is a complicated and lengthy process because corresponding experiments have to be conducted to obtain adequate data, and these data have to be examined by the drug approval administrations. However, a patent right has a term period, which is usually 20 years measured from the date of filing of the patent application. The drug registration process may take a large part of the duration of the patent right actually enjoyed by the drug. Again, on the other hand, the generic drugs also have to go through the drug registration before they enter the market. And for doing so, the drugs should have been manufactured. So the question is, when can they legally begin manufacturing the drugs for the regulatory approval? If the answer is after the end of the patent term, then during the preparation period and marketing approval process of the generic drugs, the patent holder actually continues to maintain the exclusivity on the market, which is not fair. And if the answer is before the expiration of the patent, normally the manufacturing is considered as an infringement of the patent right. So can the generic drug manufacturers get sued for this special kind of manufacturing, and before which administration should the case be brought? We know that assessing a patent infringement is a very professional work. The Drug Approval Administration is not responsible for and not capable of doing this job. If a generic drug company affirms that its drug is not infringing any patent, or the patent is not valid, the Drug Approval Administration cannot decide if it is true, and thus cannot decide if the approval process should go on. Usually, it is the competent court specialized in patent who can decide. And in China, if one would challenge the validity of a patent, it should bring the case before the patent office. In case any dispute is engaged between the patent holder and the generic drug company, should the approval process of generic drugs be stopped? To answer all these questions clearly, a mechanism is needed to coordinate the actions of separated administrations, namely the Drug Approval Administration, the Patent Office, and the court. So the Pharmaceutical Patent Linkage System is such a mechanism to link the marketing approval for generic drugs with the patent of innovative drugs. It was first established in the United States through the so-called Hatch-Waxman Act in 1984. Within the framework of this act, the United States has established a comprehensive and elaborate mechanism for balancing the interests of innovative drug companies and generic drug companies. This system comprises the patent term compensation, the data protection, BOLA exemption, abbreviated new drug application called ANDA, and the so-called patent linkage system, which includes mainly the Orange Book, the patent statement, the waiting period of 20 months, and market exclusivity for the first generic drug company. We will see it in detail in the following slide. So here is a schema showing the content of the Hatch-Waxman Act. We see here the Orange Book published by the Drug Regulatory Department, which is the FDA in the United States. So the patent owner of innovative drugs should register or record its patent information on the Orange Book, which is consulted by the generic drug manufacturers. When applying for a generic drug, the applicant for generic drug applicants can apply for an abbreviated application and should make a patent statement with regard to the patents existing recorded in the Orange Book. The filing of ANDA can be regarded as an infringement act under American patent law, and thus the patent holder may launch a lawsuit against the generic drug manufacturer if he finds that the generic drug infringes his patent. In this case, the FDA will hold the approval process for 30 months. On the other hand, the applicant for generic drug may file a patent statement of type 4, which means that he will challenge the validity of the patent. The advantage for doing so is that if the patent is successfully invalidated, the first generic drug manufacturer who did it can enjoy a market exclusivity of 180 days, well, about 6 months. Thus, on one hand, the implementation of the pharmaceutical patent linkage system can encourage the generic drug companies to resolve the patent disputes before the generic drugs are approved for marketing and reduce the risk of litigation after the marketing of the drugs. And on the other hand, it also enables an open and transparent process for approving drugs for marketing and facilitates proper assessment of the drug infringement risk to avoid unnecessary disputes. Now let's see the actual practice in China. For quite a few years, according to the former drug registration management measures, applicants for regulatory approvals were required to list out known patents in relation with their drugs and to declare that their drugs would not infringe these patents. However, there was no consequence if the declaration is wrong, and there wasn't any channel for the patent holder to challenge these declarations. As a result, this declaration mechanism did not form an effective way to resolve the patent-related disputes. Then in 2018 and 2019, the General Office of China Communist Party and the General Office of the State Council jointly issued 2 documents, the 2 opinions, in which the goal to establish a patent linkage system is established. However, It is disappointing that in the new Drug Administration Act and the corresponding drug registration management measures, there were no clause about the patent linkage system. On the other hand, in the meanwhile, from the third amendment to the Chinese patent law in 2008, BOLA exemption has been introduced in China, which excludes the manufacturing, using, or importing patented drugs or patented medical devices for the purpose of providing the information required for administration, examination, and approval from the infringement of patent rights. In other words, before the expiration of related drug patents, the generic drug companies can already manufacture the generic drug for marketing approval process without the risk of being sued for patent infringement. This BOLA exemption has long been criticized as the naked BOLA exemption, because the patent holder cannot do anything to stop the infringement, even if the manufacturing is not only for the purpose of marketing approval, but also for the marketing itself. Thankfully, from 2020, a series of measures and concrete provisions are carried out by the Chinese government. On 11 September 2020, the National Medical Products Administration, the NMPA, which corresponds to the FDA in the US, formerly called CFDA, and the National Intellectual Property Administration jointly issued the draft implementation measure for early resolution of pharmaceutical patent disputes for public consultation. The early resolution measure provides a mechanism to allow the patent owners of innovative drugs and the generic drug applicants to resolve the disputes on the validity and infringement of the patents concerning such generic drugs. This is the first time when an early resolution mechanism has been introduced into the legislative pipeline in concrete provisions. So this early resolution measure provides the following procedure, which is somehow similar to the US patent linkage system. First one is the recordal of applicable patents on the platform. The NMPA will establish a recordal platform, which is similar to the Orange Book of the US, on which the patent owners should record their applicable patents when applying for the regulatory approval for their innovative drugs, or within 30 days from the grant of the patents if the relevant innovative drug has already entered in the marketing approval process. The applicable patents for chemical drugs may be the pharmaceutical compound patents, or the pharmaceutical composition patents, or usage patents. And for biological drugs, it can be the sequence and structure patents. And for herbal medicines, it could be the pharmaceutical composition patents, herbal extract patents, and pharmaceutical usage patents. And the second one is the declaration by generic drug applicants. So the generic drug applicant, when he applies for the marketing approval for his generic drug, he is required to review the applicable patents recorded on the platform and make one of 4 types of declaration with respect to each patent. The type 1 is that no applicable patent is recorded on the platform in relation with its generic drug. And type 2 is that the applicable patents recorded on the platform are either expired or invalidated. And if type 1 and type 2 declaration is made, the NMPA will determine whether to grant the regulatory approval according to the technical evaluation. And the type 3 is that the applicable patents recorded in relation with the generic drugs are still valid, and the generic drug applicant will not market the generic drug until the expiration of the applicable patents. And if the type 3 declaration is made, the NMPA will determine whether to grant the marketing approval according to the technical evaluation, but it will add a remark that the generic drugs must not be marketed until the expiration of the patent. And the type 4 is the most exciting part is that the generic drug company, the generic drug applicants declares that although there is a patent in relationship with this generic drug, but this patent should be invalidated, or the generic drug does not fall within the protection scope of the patent. According to the early resolution measure, in this case, the generic drug applicants must also file supporting documents alongside with the declarations, but which documents are not specified yet. So once the declaration is published, a patent owner may initiate a judicial proceeding or bring an administrative action within 45 days if he does not agree with the declaration. If the filing of such legal proceeding, judicial proceeding, or administration action is accepted, the patent holder should submit a copy of acceptance notice to the NMPA. And in this case, a waiting period of 9 months is given during the marketing approval process of the generic drug. The waiting period begins from the acceptance of the judicial proceeding or administration action. During the waiting period, the NMPA will not suspend the technical evaluation of the generic drug, but will not grant a marketing approval for it. If within the waiting period, the judicial proceeding or the administrative action confirms that the patent covers the generic drug, the NMPA will suspend the marketing approval process until 20 days before the expiration date of the patent. Or if the judicial proceeding or the administrative action confirms that the generic drug does not fall within the protection scope of the patent, or the patent is not valid, the NMPA will continue the marketing approval process. And if no judicial proceeding or administrative action reaches a decision within the waiting period, the NMPA will continue the marketing approval process after the expiration of the waiting period. And finally, if the applicable patent is successfully invalidated by a generic drug applicant, the same person will enjoy a market exclusivity of 12 months, or the remaining term of the patent, which has been successfully invalidated, whichever is shorter. So during the market exclusivity period, the NMPA will not grant marketing approvals for subsequent generic drugs of the same compound or composition or usage according to the time of the invalidated patent. The introduction of the market exclusivity period indicates the government's intention to encourage the development of generic drugs. To compare with the United States patent linkage system, we see that waiting period of 9 months is much shorter than the 20-month stay in the US. In fact, different countries have set different waiting periods. For example, in Canada, it's 24 months, and in South Korea, it's 9 months too. Can this 9 months be too short? Maybe. According to actual practice, the Beijing IP court is usually, which is the unique jurisdiction for this kind of disputes. Beijing IP court is usually overloaded, so it could be difficult to complete the litigation in 9 months. And another difference is the duration of market exclusivity for the first generic drugs. Compared to the 180 days in the US or the 9 months in South Korea, the 12 months in China is relatively long and should encourage the generic drug manufacturers to challenge the innovative drug patents. And another difference is the monitoring. In the US, the generic drug applicants who submit the type 4 declaration must notify the patent holder in a timely manner. The patent holder has 45 days to file a lawsuit. The 45-day time limit starts from the date when the patent holder receives the notification. While in China, the generic drug applicant does not have to actively notify the patent holder. Therefore, in order to initiate the litigation in a timely manner within the 45-day time limit, the patent holder should pay close attention to the NMPA's publication of the application and declaration of generic drugs. And later, 2020, in October, the Fourth Amendment to Chinese patent law has finally been approved and will come into effect from the 1st of June this year. The newly added Article 76 will serve as the legal basis of patent disputes during the marketing approval process of generic drugs. The disputes can be resolved by filing a lawsuit with the People's Court or requesting the Patent Administration Department for an administrative decision. Here, please note that the Article 76 only mentions the lawsuit or the administration, the lawsuit to decide whether the generic drug falls within the protection scope of the patent, and does not mention the validity of the patent. It is because the validity of the patent is exclusively examined by the Chinese Patent Office, which is different from some countries. A few days later, after the publication of the Fourth Amendment to the patent law, the Supreme People's Court issued a document named Provisions on Several Issues Concerning Application of Law to the Trial of Patent Civil Cases Involving the Evaluation and Approval for Drug Marketing. That is too long. Wherein some clarifications are given. For example, all the cases under the new Article 76 should be filed with the Beijing IP Court, and only the patent recorded on the platform are applicable. According to the Article 12 of the provisions, the decision of the court should specify if the generic drug partially falls within the protection scope of a patent. And finally, under the new Article 76 of patent law, both judicial procedure and administrative procedure can be launched. The provisions issued by the Supreme Court stipulates that an ongoing administrative procedure will not stop the judicial procedure. However, according to the draft measures provided by the Chinese Patent Office, if the case has been accepted by the Beijing IP Court, and the Patent Office will not accept the case once again. Thus, three routes are available for the litigation strategy under the Article 76. It's only the administrative action or only the judicial action or both actions. But in this case, you have to pay attention to the starting time of each proceeding. The advantages and disadvantages of different routes are still to be observed. And a related issue is the patent term compensation, which is also newly added in the Fourth Amendment to patent law. Strictly speaking, it is not part of the patent linkage system itself, but it is also an important part in the balancing of interests of innovative drugs and generic drugs. we see that in order to compensate for the time taken by the marketing approval of patented drugs, China has also established a system for extending the term of drug patents so as to avoid the shortening of the effective patent term caused by drug registration, and thereby encouraging the pharmaceutical companies to continue investing in R&D of innovative drugs. Similar to the rules of the United States, the extension period is not more than 5 years, and the total effective duration of the patent right shall not exceed 14 years from the marketing of the new drugs. And later in November 2020, the draft implementing regulations of the patent law provides in detail the method for calculating the extension term and the scope of protection, the definition of new drugs, and the time of filing the extension request, and so on. We will not develop all the details herein because the time is up. So thank you for your attention, and open for the questions.